Good afternoon, everyone. Thank you very much for joining us for this session regarding the August 2024 exam papers. As you know, Council does not allow us to publish any answer guides or answer memos after the exam, and this is for your benefit. You will note that those who didn't rely on any past papers would have done better in these exams than you may have done previously. But what Council has decided is that after each exam, we're going to have a webinar where some of our examiners or moderators will just do an overview of the paper that you've just written to give you some feedback on where you may have gone wrong, so you can understand the paper properly, and you also know how to better prepare yourself for next time if you do have to write the next exams. For those who for those who are doing oral exams, we also hope the session helps you just to know how to answer questions and how to see exactly what it is that we're looking for. How the session is going to go today, you'll see that the exam papers are on the screen. So we're going to go step by step through each of the papers. We've got a different presenter for each paper, which I'll introduce as we go. We may not be able to take questions, but if you have, you may put them in the Q&A box, and we'll see how much time we have. Otherwise, we will give you the email address where you can direct your questions after the session. So we're going to get straight into it with paper 1. Presenting this is Mr. Thomas Minnie, who was involved in the exam process and moderating the exams that you've just written. The paper you'll see on the screen, you can follow along. Please make notes as you go. This session will also be posted to YouTube after the session today. So if there's anything you miss, you're welcome to go and watch it again. And also if there's anyone who doesn't make it to the session today, they can catch up and watch it on YouTube. Mr. Minnie, I'm going to hand over to you. Thank you very much.
Thank you very much, Melissa. Thank you for the opportunity to give this feedback to the candidates. It's rather heartwarming to see that there is at least 330 candidates who consider this to be valuable, and that we are there for those candidates who make the effort to avail themselves for these kind of sessions. But thank you very much. So before I get started into the paper itself, I just want to turn to the very first page. It's the instructions to candidates, and too many times we don't pay enough attention. I don't think candidates understand the importance of this page when writing the exam. So let's start there. Firstly, we had papers that there was answers answered which we could not mark, and we could not mark them for two reasons. The one was they were written on the wrong side of the page. The instruction number three clearly says on the right-hand pages only. Candidates wrote on left-hand pages, they wrote in pencil, and they used Tipp-Ex. Candidates have to be aware that those components or parts of the script that are written on the wrong page, that are written in the wrong color ink, and that are written and are corrected with Tipp-Ex will not be marked. It is extremely important to adhere to that. The next aspect was the aspect number 4, and that's candidates must remember that marks are awarded for good draftsmanship. Now, I think that good draftsmanship is taken superficially. If I can tell you, and my colleagues will verify what I'm saying, some of the scripts were written, and I can only use the word absolutely horribly in respect of handwriting. Candidates must remember that the markers, if they struggle to decipher their handwriting and the paper looks shoddy, it sets a tone for the marker. You want the marker to mark clearly, to be satisfied himself that he reads is what you intended. When you scratch out and it's backwards and forwards and arrows this way and arrows that way, it becomes very difficult for the marker to find the marks. And the temptation for the marker will be to simply ignore what's written on the page. So make it simple for the marker to follow you. Write clearly, If you make a mistake, sketch it out neatly with a ruler, correct the answer. If you see that you've made numerous mistakes, rather write the entire answer over. But it makes it very difficult to award marks to candidates when the paper is shoddy. So please pay attention to the manner in which you answer the questions. And I'm talking there, as I say, only the way you present it. And like I said, the biggest complaint there would have been the handwriting. There was some candidates' handwriting is simply illegible and extremely untidy. Candidates just used the pen and just scratched. They didn't even try and draw a line neatly over it. They just scratched it dead. But that in as far as the presentation is concerned. Then when we go into the paper itself, thank you, Melissa. When we go into the paper itself, I'm going to start with the first question. Now, I'm going to make four general observations that we picked up during the examination marking process, and it was the following. It is clear from the results and from what was seen in the answers that there are four major causes of concern and areas where candidates must go and brush up on their skills. And the one was, it is clear that candidates do not read the question. You will find that in certain questions that are, the parties, for example, are provided. They are clearly given. And then the candidate invents a new plaintiff and a new defendant. It becomes very difficult for the marker once again to figure out who these new parties are that the candidate is referring to. Read the question, because remember, the question is posed with a certain facts. And what the examiner is attempting to achieve is for you as the candidate to peruse the facts given, and from the facts to then deduce what the answer will be. The facts are given aren't just there for filling up the papers. They're there for a reason. It is to give you a roadmap, for you to use in finding the answer. That then flows onto the second component that's the major concern, and that is candidates do not answer what is being asked. They come up with an answer, it's an elaborate answer, but it has absolutely nothing to do with what's being asked. And like I say, those two probably run hand in hand. Then the third concern is that it becomes clear in the answer sheets that candidates do not know which form, the process to apply to a given set of facts. The South African legal system works on forms and it works on processes. And clearly, the candidates do not understand which process and which form applies where. So please, you must go and brush up on those skills. And then the last thing, and this is an absolute no-no when it comes to the paper, and that is, it is obvious that candidates have not gone and studied the rules of court. In South African litigation, the rules of court, both magistrates and high court, and in most of the other forums, the Labour Court, the CCMA, all have their own rules. You have to learn to operate under a set of rules, and you must have an idea of what they say. It is not expected of a candidate to know each and every rule verbatim, but there are certain rules that you work with every single day, and those you need to have a detailed knowledge of. It is for that reason that on certain of the questions, all that was required was for the candidate to provide an indication that they understand how the rule works. They didn't have to give the exact wording, and they were awarded the marks. So please, you must go and study the rules of court and understand how they all link together. Right. Then if we have a look at question one. Question one, Melissa, I just want to check it. Is that on the... Yeah. Question one related to a set of facts, and it was in respect of a collision, and damage was suffered in regards of what we refer to, the easy term is blikskade. Damage to the vehicle. which amounted to 460,000 rand. Now, the 460,000 rand is already your first clue. And then it's being the fair and reasonable cost of the repair to the vehicle, restoring it to its pre-collision condition. Okay. So what did we see? Now, generally, what we're looking for was the you had to understand the concept of a cause of action. The facta probanda and facta probantia, which flows from that. But let's limit it to the cause of action. Because if you understand what is required in different causes of action, then you would have seen from the set of facts that certain allegations were omitted. Okay. Now, the cause of action can, in layman's terms, can clearly be set out as it's those set of allegations which must be set out in your particulars of claim, and if proven successfully, will lead to a successful action. Okay, so what we were looking for was the heading. Let me just have a look, see if this was, yes. It clearly says that the question, once again, include the heading, but you may omit the ending. So in as far as the heading was concerned, what we were looking for was the court. Now, you will see that because of the quantum, this was then in the High Court. Okay, and it was where the cause of action arose, which was in Pietermaritzburg or in Natal. Okay, so that was what the examiners were looking for. The form is specifically asked in the question. It says, draft a necessary notice, application, or pleading. In other words, the examiner wants to know, do you know that the document, or can you determine from the facts whether the document which is being asked for is a notice, an application, or a pleading? And for that, you would have got your mark for setting out the correct notice of exception, because that was what they were looking for. Now, going back to the allegations which were required, you will see that this is the question requires you to answer it, that the document, that the objection that you can raise against the summons is an exception, and the grounds for the exception was that the cause of action was not successfully set out. Okay, so it fails to set out the necessary allegations for damage to a motor vehicle in a motor vehicle collision. And the two allegations which were required was that the plaintiff has to be the owner of the vehicle. Alternatively, the plaintiff has to be the party to which risk of loss had passed. Okay, you'll find that many times, a plaintiff is the possessor of a motor vehicle, but the owner is the bank, because ownership has been reserved in terms of the agreement of purchase of the motor vehicle. But the risk of loss has passed to the plaintiff. So it could have been either one of those, because that then gives rise to lower standard to implement the action. And then, of course, the second one which was omitted was an allegation made that the damage was caused by the negligence of the defendant, and then set out in which way the defendant was negligent. Okay, so the common mistakes which we picked up was that the candidates did not know which court they had to issue the process in, and they also did not know which process was required. You found candidates writing a letter. You found candidates drafting a particulars of claim, and numerous other hybrid type of processes, which was not what the examiner was looking for. Okay, so what we needed was we needed the court, which was the High Court, and it was in the KwaZulu-Natal division of Pietermaritzburg. We needed you to say that you raise an exception against the particulars of claim. we needed you to say that the allegations lacked ownership or that the risk had passed to the plaintiff, and that was for 2 marks. And then we also needed you to say that it was the sole cause of the negligence by the defendant. And then the prayers, which I think many candidates left out because they might have understood this, where it says, but you may omit the ending, i.e. the particulars and or registrar. Now, what the ending of a process is the details of the attorney or the party of the plaintiff or the party who gives out the notice, as well as the registrar or the clerk or whoever the case may be, depending on the forum that you litigating in. But what we did want was that you pray for the exception to be upheld, that the plaintiff's particulars of claim be set aside with costs, and that the plaintiff be given leave, if so advised, to file amended particulars of claim within a certain period of time. In this case, it was 1 month. So that is what was required for question 1. Then on question 2 was action based on an acknowledgement of debt. Therefore, from the set of facts given, it is clear that the acknowledgement of debt is the instrument upon which the action was based. Now, if we have a look at the question once again, the question tells you, gives you certain road markings and indicates the way to go, gives you the roadmap in that the amount, for example, is 1.2 million rand. You will immediately then realize that this is a case which must be heard in the High Court. Now, it goes even further. And this then goes back to the fact that students don't read the question. If you have a look at the question, it clearly says that your client is James Jones, a major adult carpenter, who hands you a summons issued from the Eastern Cape Local Division in Bishu. If I told you how many students presented a document which then indicated a different court, you would honestly think that I'm lying. So the question clearly gives you the court where it must be heard, and then students change it. Now, that was the easiest 1 mark of this paper, because all you had to do for the 1 mark in question 2.2 was to simply repeat it and say in the High Court of South Africa, Eastern Cape Local Division, Bishu. Okay, so this question dealt with a special plea, and I'm not going to explain to you what a special plea is. That is a theory question. You can go and study what a special plea is yourself. It's been asked in numerous papers prior to this one, and as well as what the different special pleas are. Those are aspects of litigation that are dealt with on a daily basis. Attorneys will raise special pleas, so you must know that. Okay. The heading, as I say, was determined from the facts. Which court was also determined from the facts. There are 3 aspects to the special plea which must be addressed. Okay, and it was the defendant's residence. So you could base it on the fact that the defendant resides outside the area of jurisdiction of the court, and that the cause of action arose outside the area of jurisdiction, because it tells you where the acknowledgement of debt was entered into. Okay, so those are the aspects which we needed you to canvass to receive the marks, and then obviously also praying that the plaintiff's claim be dismissed with costs. That also gave you 2 marks. Question 3, just quickly page down here. Yes, so the common mistakes of question, I just want to quickly go back, sorry, I omitted this question. The common mistakes which were made in question 3 was that the candidates needed to address the aspects as I've said, but that candidates simply failed to do so, and they embarked on writing a letter. Question 3, those court days, I can tell you, the first one is 20 court days, the second one is 10 court days, the second one is at least a month, and the third one is at least a month, and the fourth one is the 16th of December to the 15th of January. Ladies and gentlemen, it's not from the middle of December to the middle of January. It's not from about the 15th of December and about the 15th of January. Those dates are cast in concrete and they are stipulated in the rules. The answer required a complete answer. In other words, if you gave the date in December wrong, but you got the date and the month of January correct, you did not obtain the mark. We wanted the complete mark. The answer is simple. It is 16 December to 15 January. Okay. Question 4 was the requirements, if I can remember correctly, was interim interdict. Yes. Question 4 was for the interim interdict. Once again, theory question. It is a component of law which is dealt with quite regularly, and you normally find that these applications, just as a matter of interest, piggyback on a question, and maybe you might find yourself answering such a question in the near future. It piggybacks on an urgent application because an interim interdict is normally granted on an urgent basis, as there is the 4 elements. If you understand the 4 elements, then it will make it obvious that there is a prima facie right that's being infringed upon. Irreparable harm will take place if it is not addressed, and the balance of convenience will favor the applicant, and that there is no alternative remedy which the applicant can follow but to approach the court. Okay, so those are the 4 aspects that had to be covered for the marks to be awarded. Right, then as far as question 5 is concerned, question 5, let's go down there. My notes, sorry. Question 5 dealt with the Magistrates Court practice, and it was, let me quickly have a look. Yeah, it was 80,000 Rand for damages. Okay, so what was required from that question was for the candidate to understand that when you're dealing with a firm, there is a specific rule which regulates the obtaining of the names of the persons involved in a firm. And that was the answer which was required. We needed candidates to indicate that they understood that a notice may be drafted and sent to a plaintiff firm indicating the names and addresses of the owner of that firm. In other words, the parties who made up that firm. And that was what was required. We also then required the candidate to indicate a period of time. Although the rule specifically makes provision for 10 days, the candidates were granted some leeway there as long as the time was reasonable in which the plaintiff, who would be the respondent in this application, was given to provide the names and addresses of the firm members. Okay. Question 5.2.1. Question 5.2 says that in this matter, the plaintiff delivered notice which reads as follows: the plaintiff hereby withdraws its claim against the third defendant. You correspond with the plaintiff's attorney to protect your client's interest. Neither the plaintiff nor the attorney reply or react in any manner to the correspondent. to your correspondence. Your client instructs you to approach the court to protect their interests. Now, what you can see here is, once again, testing your understanding of the rules. What we have is a plaintiff who has withdrawn a claim, an action against the third defendant. The third defendant has already consulted an attorney. We don't know to which extent the third defendant has already incurred legal costs, but rest assured they have. And that is what this question dealt with. It dealt with the protection of your client's rights in respect of the costs. So what we were looking for in question 5.2.1 was that you must approach the court for an order that the plaintiff pay the costs of your client, who in this case was the third defendant, and as well as obviously the costs of that specific application that you then bring to court. Okay, question 5.2.2 then asked, within how many days should this be done? That's a theory question. When you go look at the rule, it's stipulated in the rule itself, and that is within 20 days of the service of the notice that the plaintiff serves on the third defendant withdrawing the action. So within 20 days from that date. Okay, and then the 5.2.3, I think, was the second easiest mark on this exam paper, and it is, should this be done by way of action or application? So you had a 50% chance of getting it right. It was simply, and you simply had to answer whether it was an action or an application. If a candidate understood the process and simply applied the facts, you will see that the facts relate to a summons which was already issued. So it's an application, a action. So you couldn't have had an action within an action. So it would obviously have been an application, interlocutory application. Okay, then it goes further. Question 5.2.4, what additional step should be done if the notice was served on you 3rd of April, and it's now the 21st of August. So in other words, it clearly indicates that you're out of time. So what we were looking for was an application for condonation. Condonation application is something that attorneys deal with on a daily basis, and candidates would be expected to understand the application and when you apply and how you apply for condonation. All right. Then question 5.3, once again, the roadmap was provided. It stated that following from 5.2 above, draft the necessary court document. Now there you can see again, the examiner does not give you the specific court document. They simply ask you to draft the document. And here again, we had a variety of documents arrive and be presented by candidates, ranging from affidavits on their own, affidavits made by attorneys, letters, particulars of claim, types of setting out details, and so on. So that was all incorrect. What we were looking for was an application where the applicant applies to court for an order that the first respondent, who would be the plaintiff in the main matter, be ordered to pay the third defendant's costs. So, ladies and gentlemen, these types of processes happen regularly in litigation, that the plaintiff and defendants, or defendants, depending on how many there are, in matters become applicants and respondents. And it's not necessarily that the plaintiff will always be the applicant or the defendant will always be the respondents. In this case, you can clearly see what happened was that one of the defendants became the applicant. And to be thorough in these kind of applications, you should refer to the parties both in their original form as well as in the form of the document you are presenting to court now. In other words, the applicant in this matter, you would cite as the applicant and third defendant. So that the court knows that this is an application brought by a defendant in an action. All right, and then obviously the marks were then awarded for asking for costs of the action as well as the costs of the application and addressing it to the clerk of the court. Right. Question 5.4. It states when the matter is heard, the magistrate immediately finds against your client. Your client wants to appeal the finding, and here is once again the indication and the roadmap. It says, wants to appeal the findings but does not know why the magistrate found against her. The alarm bell sits in the statement but does not know why. If you understand, which is expected from a candidate to understand both the appeal and review processes from the Magistrates Court to the High Court, then you would know that in order to lodge an appeal, you would have to have knowledge of the reasons for the magistrate making their ruling, because it is against those findings that you will be appealing. So what you would request in order to proceed with this matter, and that is the question in question 5.4.1, is that you would need to request reasons for the judgment from the magistrate. That is a specific rule in the Magistrates Court rules, and you can go and find that specific rule and read up on it. Make sure that you are afraid, because I can assure you that aspects of appeal and reviews are regularly tested in exam papers. Okay, and then question 5.4.2 is simply asking you to draft the necessary notice of appeal. So what we wanted to see was that you knew that the notice was one that was addressed into the Magistrates Court, because remember, you are asking for the reasons from the magistrate, so you address it to the magistrate. You indicate the parties. Those parties were once again awarded marks for each party. And here you will find is a very good example of where we found students simply changing the facts. Question 5 clearly states that your client must BD, and that there was a firm named ABC. So the parties that we were looking for in the answer sheet was BD as the appellant and ABC as the respondent. And yet we received all sorts of Mrs. Jones and Mr. ABC trading as, and all kinds of things. But it was easy marks because the marks were given to you, the citation was given to you in the exam paper. All right, and then all it was the notice of appeal, which was which you then had to draft and present. Okay, that notice of appeal, you can go and read that yourself. It's not a difficult notice. It simply states that please take notice that the appellant, third defendant in the action before the Magistrates Court hereby notes an appeal against the findings of the magistrate, and you then put the magistrate's name in, on which date they made the findings, in that she dismissed the third defendant's application for costs. That was a mark. Okay, and then you indicate whether you appeal against the whole of the judgment in the application for costs. All right, so that was as simple as that. Then in question 6, it was a motor vehicle accident, and so many students elected to address this answer on the basis of a road accident fund. It is not. It was motor vehicle collision. I see that I'm taking lots of time here, so I need to rush this quickly. So, ladies and gentlemen, it was not a difficult question. What we wanted was the particulars of claim. It was a 13-mark question. So we wanted the plaintiff, who the plaintiff was. Remember, the rules of court say you must cite their address. You must also say the defendant is. You must also cite their address. You must stipulate that the court has jurisdiction to hear the matter, and then the basis. Normally, you set out the basis for that jurisdiction, whether the party resides there, and the complete cause of action, and then you set out the facts that gave rise to the collision, on which date, where, what the registration numbers were, that the plaintiff once again is the owner, or that the risk of the loss resided with the plaintiff, that the collision was caused by the sole negligence of the defendant, and that the result of the collision, the loss was X amount, which according to the question was 150,000 rand, which is the difference between the current state of the vehicle and the pre-collision value of the vehicle. And then that despite demand, the defendant refuses to make payment. Okay, so that in as far as question 6 was concerned. Question 7 is simply taken out of the Act. You can go and have a look at it. It was a list of all the documents. Those documents were given, they in your notes. It's the RAF claim forms, it's the certified copies of the claimants, police collision report, etc. If you named any of them, there were eight easy marks awarded. Then with regards to question 8, exactly the same. It specifically asks for 2 different scenarios. It's got to do with the road accident fund. When will the following claims prescribe in both lodgement of the claim with the road accident fund as well as the service of the summons? Ladies and gentlemen, many students here only answered one component of the question. What was asked was claims prescribed in terms of both lodgement as well as service of summons. And then the 2 difference was the unidentified claim hit and run, where the injured claimant is a minor, and an identified claim where the injured claimant is a minor. And you can go and find those 2 answers in your notes. They are clearly indicated. And then with regards to the criminal component of the question paper, Section 112 statement in terms of the Criminal Procedure Act is set out in your notes. This question has been asked ad nauseum in question papers. Every single student should have got full marks for this question. The common mistake in this question is that the document is drafted. It says draw section 22 plea 112 plea explanation statement on behalf of your client. Yet the attorney drafts it and signs it and puts his details underneath. The attorney is not on trial. The attorney cannot enter into a plea explanation. It is wrong, and it is fatally wrong. It is the accused, being your client, who must set out these facts. Okay, go look at a section 112 plea explanation in your notes. It is not the attorney that sets it out. Okay, and it is not an affidavit. It is a statement which is made by the accused. All right. Then question 10 was the different forms of sentencing, which was a fine, imprisonment, periodic imprisonment, declaration as a habitual criminal, correctional supervision, and a postponed sentence. Then there were the question 10.2, give reasons why bail may not be granted to an accused person. There are numerous reasons, and those reasons you all have them. I'm going to rush through them quickly. That the accused is a flight risk or attempt to evade trial, that the accused will endanger the safety of the public or will commit a Schedule 1 offence, that the accused will attempt to influence or intimidate state witnesses, that the release of the accused will undermine or jeopardize the objectives of proper functioning of the criminal justice system or the bail system, that there are exceptional circumstances that the release of the accused may disturb public order or undermine public peace. Those aspects are stipulated as such in the Act itself. You will find them there if you go and have a look. Then the further question 10.3, in terms of which section can an accused person make admissions and confessions? The answer is section 220, but your attention is also drawn to section 217 and 219A. Go and have a look at the difference between those three sections and see how they differ in their application in regards of the criminal procedure. Okay, and then the next question was the role of the prosecutor in a criminal court. That is a theory question. You can go and study that in your own time. And once again, and then question 11 as well. The court has convicted an accused person on a charge that has a minimum sentence application. In other words, what the question wanted to know was, under which circumstances can a court divert from the minimum sentences? And it was where the accused was a juvenile under the age of 16 years at the time of the commission of the offense. That was the first one. Where the court where the court has found that there exists substantial and compelling circumstances which warrant a departure from the minimum sentence provided for in the Act. Okay, and that was section 51 sub 3A of the Criminal Procedure Law Amendment Act. And then the court, how does the court do it? The court enters the substantial and competent circumstances found to exist on the record of the proceedings before proceeding to impose a lesser sentence. In other words, the court must make a note of what it considers to have been those substantial and compelling circumstances upon which it based its election to divert from the minimum sentences. That then, in a nutshell, ladies and gentlemen, the question paper, like I say, was a good mix of some good theory questions. A lot of the questions were simply from forms and processes taken out of your study guides, so they weren't difficult. And yes, I think in preparation, like I said, the important part of my feedback was the beginning, is those 4 aspects which the students miss on a regular basis. I do apologize for exceeding my time, but I think it was important. Thank you very much to everyone.
Thank you very much, Mr. Mini. Thank you very much for taking us through paper 1, the court procedures paper that candidates wrote in August 2024. Candidates, I hope that we've unpacked that question paper for you. You can see where maybe you may have misinterpreted the questions, where you may have gone wrong, and hopefully you know where to improve the next time around. I'm now going to hand over to Mrs. Vanessa Johnson, who's going to take you through paper 2, our wills and estates paper. Thank you, Vanessa. Over to you.
Thank you, Melissa. All the attendees of this meeting, I am so happy to see so many of you. And I just want to congratulate you that you at least succeeded in getting an oral for this examination. And you have to see this opportunity as a new and a next opportunity. Put the past behind you and take this opportunity. Study hard for the orals, because most of you, if you study hard and if you do the right thing and you understand the estates, you will pass the orals. The examiners during the orals are not there to try and make it difficult or more difficult. They are simply trying to see whether you understand estates. And that was also what we were looking for when we marked your estate scripts. Now, I know that in practice, candidate attorneys often underestimate the estates examination. They think that if they can do the L&D account, they will be able to pass, especially in a paper like this one, where the L&D account was for 70 marks. So you would think that to get 50% or 50 marks for the L&D might have pushed you through, or you get 35 and you only need 15 more. and it could happen, but we did not really find that that was the case. We found that students who understood the L&D account, who knew how to do the L&D account, and who did the L&D account according to what they studied, they did well. But they were also the students who did well in the intestate question and the theoretical questions. In this case, it was the wills question and the theory for the that was section 32, the last question. So I want to emphasize the fact that estates mainly is concerned with the L&D account, which will always form part of the biggest part of your estates. Then the intestate question, there will always be an intestate question. Then a wills question, either draw a will, draft the will, draft sections of the will, or or theoretical wills questions, like for instance question 3 in this paper, and then other theory questions, which you will never know which ones you are going to get. But if you study for the L&D account and you study for the intestate succession and you do the wills, you have covered everything. You cannot decide that I'm only going to do the L&D account and leave out the intestate, or don't study intestate that well. So in essence, I'm not going to go through each and every question as the mini did. I am more going to give you, I'll quickly go through the first page of question 1, just to show you that in number 4 and number 5, it was regarding the shares that the deceased owned, and that his brother worked for him, and his brother entered into an agreement that on his death, he would buy all the shares in the business. And then 4 and 5, they give you a lot of information there. But once you understand the principles of what is an asset and what is a claim and what happens to an asset, for instance, is it sold or is it reflected as value of, obviously when it is not sold, once you understand those things, you minimize the difficulty and the unnecessary information they give you, and you simply focus on, is this an asset of the deceased? Is it an asset of the deceased at date of death? If the answers are yes, then it is reflected in the L&D account. And now you have to determine what the amount is you're going to reflect in your column, your money column. So if it was sold, you will reflect it as the proceeds of and the selling price. If it was not sold, you will obviously use the value of. But what I want, the one tip that I want to give candidates, especially for the orals, you have to know that when you get into the oral, it's a more practical situation, because you are not given a lot of information as in question 1 here, and where you have time and you can put it where you want to put it. You need to know the principles of what is reflected in the L&D account and what is reflected in the estate duty. So my tip 1 is go back to the paper and redo the paper. Now you have the liberty of taking your lead notes, your textbooks, your notes. You can ask someone. Now you can do it properly, and you can look at the information in the lead notes, for example, and see whether, and I don't even think you should look at what you have done in the examination. I think you should just simply redo it. Take this as an exercise, because in the oral examination, they are not going to ask you which assets are going to be reflected under immovable property or movable property. They are going to give you specific assets, and then they are going to ask you to put them in the place where it should be. So you always say, for instance, let's make it a simple asset, a policy that was paid out. It was on the life of the deceased. It was paid out to the executor. Now you ask yourself these questions. And when you answer the question in the oral, do the same thing. Say, yes, this is an asset of the deceased at time of death. It was a policy. So now it could be something that doesn't fall into the estate, the liquidation part, but only in the estate duty part. But this one will form part of the liquidation account. So it will be reflected under claims in favor of the estate because it was paid out to the executor. So that's just a simple example. Take the L&D account, the paper that we asked, do that, redo that, ask anyone to look at it for you so that you can see whether you have done it correctly or not. I just want to emphasize the fact that there was one error on the page, on the paper. We know that. It was number 6, a liberty policy on his life, the deceased's life, payable to his second wife. So that says it doesn't form part of the estate for liquidation purposes. It was paid directly to her as the nominated beneficiary. And then it said with a majority value of 230 and a life cover value of 500. So it should have been with a surrender value of 230,000 Rand. But I can confirm that this was only for one mark. Where we had to reflect, it was one mark. And we as examiners had two separate questions, answers for this one. So if you use the 230, we would have marked it correctly. If you use the 500,000 correctly, we would have marked it. But it should have been the surrender value, 230, and you would have used the life cover value because the life cover value of a policy comes into play when someone is deceased. Then the rest of that paper, I'm going to page 2 now, Melissa. The deceased had an investment. Remember, investment, yes. Property of the deceased, yes. Property of the deceased at date of death. Where am I going to reflect it in the liquidation account? Under claims in favor of the estate, because those are the assets that comes into rand and cent in the estate. And now the question is, if it's an investment and they say they were interest, in this case, they said accrued to date of death, it would have been reflected in the liquidation account. It will not form part of the income and expenditure after date of death. What we looked there is you saying that the capital was 708,600 Rand and the interest was 9,000 Rand. Then the liabilities, we looked for specifically whether you knew the government gazette fee of 37 Rand 82 cents for the advertisement costs. I think you will all agree that all the others there, number 3 up to number 12 or number 11 on page 3 was really easy marks. You simply had to reflect that under your administration costs. I just want to see, those were all administration costs, yes. Then obviously you need to know how to calculate executors' remuneration and master's fees. Make sure that you know that for the oral examinations because that could be asked. Question 2 was the intestate question. Now here, we often find that this is, I just want to go back to the L&D account. Remember, when they ask you the L&D account in the oral, you have to explain and you have to understand why something is reflected in a specific subsection of the L&D account. The L&D account consists of many separate, smaller accounts. You need to know them in order because Regulation 5.1 gives them in order. So you need to know them in order. And then you need to know the purpose of each of everyone. So where you can get away with that in the examination and simply know that, yes, you've seen this is the recapitulation statement and you use the proceeds of assets or cash and assets reduced to cash. Now you need to understand why you do a recapitulation. You need to understand why you do the distribution account. So I'm definitely going to refer you back for the L&D account. You have to start to study from scratch and make sure that you understand more than being able to do it, because you are going to have to explain in the oral why you do something. The intestate question, many students make mistakes there because they simply don't study the Intestate Succession Act. It is the easiest act there is. If you follow the basic rules, you cannot make any mistakes there. But just candidate attorneys don't study this, and when they get into the examination hall, they start answering this and they do not follow the logical process of determining an intestate heir. Always start with a marriage. Is it in or out? Because that determines the net value you're going to work with. Then you start with the surviving spouse. You know that she gets 250,000 or a child share, whichever is the greatest. Say that. Then you determine the child's share. Calculate that, because you get a mark for that. And now you can go back to the surviving spouse. She might have received half, so you reflect that. She receives 250 or a child share. So say, for instance, it was a child share, then you reflect that. Now you go to the other people, go through the paper, say what each and every one of them inherits, and then also remember to say who does not inherit. But for each one, you have to say why. So many students lost marks there because they did not follow the logical order of the intestate question. The wills question was not difficult. The one thing that I can tell you there, and a tip for the exam, for the oral, is study the formalities of a will, and then you have to be able to put that in a format and apply the information. So that for this question, it was an application question. They gave you a specific, they could have also given you the clause in the will. In this case, they described what happens there. And then if you have studied your will's theory questions, you would have known it was section 2 capital C. Then the last question in this case, question 4, was one of those. It was section 32. Students who studied them really had the 6 marks. Many students, and the majority of students, did not know anything about the question. We actually had a good laugh as moderators, because I work for the master's office, and the majority of papers, I think it was 99%, said that the master will give the directions. Now, the master is not authority to administer the estates. So just remember that, study your theory questions. So just to recap the tips, redo the question paper, understand why something is done in a specific way, study the formalities of a will, study your intestate succession. And in this case, I also want to tell you to study the registration of an estate, because an estate is something that is started when you register the estate, then you do the L&D account, and then or it even is before that. You do the will of the deceased, then you register his deceased estate, then you do the L&D account, and then the after completion of the administration process, which you can also look at, but study it in that. For the oral, make sure that you understand the process, so that you can answer any type of question there. For instance, how to register as deceased estate, which documents you have to lodge, and once again, understand why you need to lodge a specific document, why you need to lodge the estate with a specific master's office. Remember that you need to apply all the information you study, And at the end of the day, you have to remember that as examiners, we have a duty to determine whether we can allow you into practice. And for the estate's purposes, it is, will you be able to assist a family, assist a client to register the estate, to draw the person's will, to tell them who the intestate heirs are, and then also to administer the estate and be able to do the liquidation and distribution account. So in essence, that's my take on the matter. I do not think this was a very difficult paper. The oral will not be difficult. It will be more or less the same as the estate's paper. But remember, if you have a 40, you're not looking for 10%. You start from scratch. You have to convince the examiners that you know and understand estates. All right, that's my 2 cents on the matter.
Thank you, Vanessa. Thank you very, very much for sharing with the candidates. I think what you've covered will help those who are preparing for the oral exams, and you've given some good advice for those who maybe haven't made it yet, to start off and redo the paper and see if they can get that right, taking a little bit more time. So thank you very much for sharing that with us. We're now going to move straight into paper 3. Ms. Hajira Kara will take us through that paper. We were very happy to see that the pass rate for paper 3 has greatly improved from the first sitting of the exams. We have been contacted by candidates who've relied on the syllabus that was provided to them and studied from that syllabus. The pass rate was over 40%. And we know that at least another 10 or 15% of candidates have oral exams. So we anticipate that result to go up even more. So I'm going to hand over now to Ms. Hajira Kara, who's going to take you through paper 3. For those who have oral exams, remember to go back to your syllabus, make sure that you know the topics that were covered. But remember, in the oral, they might not stick only to that syllabus. They might ask you anything that you've learned on those topics. So please make sure that you study and you are ready for your oral exams when those come up. Hajira, let me hand over to you. Thank you.
Thank you, Ms. Murray. Good afternoon. As Ms. Murray has already indicated, we had a good pass rate in this paper. However, there were certain observations that were made that were maybe kind of disappointing to the mark allocations, because of the fact that it almost seemed as if candidates tried to spot on what to draft, what not to draft in learning and preparing for the exam. Now, unlike your other papers, paper 3 basically is an assessment in terms of how you run a practice. So while there might be a syllabus, what you must take into account is the fact that when you are evaluating a scenario and you're looking at a question, what would I practically do and what documents do I need in terms of what it is that is required from me. Now, if you look at question 1.1, that was exactly what the question was about. So if you go back to your notes and you look at the syllabus said candidates must know how to draft a power of attorney, how to do a fee mandate agreement, how to do a resolution. And it said you need to look at documents in terms of mandate. So when it comes to documents in terms of a mandate, I as an attorney, maybe in my practice, I have a mandate and a fee agreement in one document. Maybe I have them in 2 separate documents, but it's about the practicality of how it works in my office, and that's what I'm going to be drafting. Now, when you do paper 3, you must bear in mind, and this is for all your oral exams, when you sit in front of the examiner, it is basically you who wants to enter into the profession and the examiner. So it is what are you as an attorney. It is not what you do in your practice and what your principal does and what he's accustomed to do or she's accustomed to do. It's what would you do as an attorney. So it is based about you in your individual attorney's world. You take that experience, but it's not said that, well, you shouldn't approach it in the sense that in my firm, we do it like this. So this is the only method in terms of which it can be done. Now, if you look at question 1, it was about 3 directors. So the word directors already should have been your keyword. And like my colleagues have already said before, in that from my colleague who already presented on paper 1, candidates don't read their questions. Some of your guidelines are directly in the questions. You need to read the question, absorb it, and work from there towards the answer. So already when it said Mr. Joe Soap is one of 3 directors, we already know it's a company, which means somewhere along the line, I would need a resolution, most probably. Now, when it said they give you a set of facts and they want to sell this business, and they ask you basically you need to draw up certain documents. And when we get to 1.1 after the facts, it says, what document would you as a legal practitioner prepare and conclude with the seller in order to proceed with the aforementioned instruction? Now, if you look at it, who is my seller? Mr. Joe Soap is one of 3 directors who acts on behalf of the company. In other words, Joe Soap was the seller. He acquires, Mr. Soap inquires regarding the sale of the business as a going concern to Mrs. Khan, who is an individual. Now, what document would you as a legal practitioner prepare and conclude with the seller in order to proceed with the aforementioned sale? Now, remember, we must not read in facts into questions. And a lot of the answers that candidates provided were based on presumption, that it is presumed that you already had this information or you had this, which would not always be the case. So you'd require from them an engagement letter, a mandate, a power of attorney, because in process, how does it work? You were consulted by Mr. Joe Soap, and Joe Soap is one of the directors, meaning there would have been a resolution which authorized Joe Soap, who then would be able to give you a power of attorney to say, this is what I want you to do for me. And of course, this question has come up in many different ways. In the previous exam, you had to draft a mandate fee agreement. I need to get, and it is part of the code of conduct, which says I need to get instructions and I need to discuss fees. So that is what I'm going to do. In terms of 1.2, what document would you require from the seller to show Mr. Joe Soap as proper authority? Of course, that's going to be your resolution. The next question was draft this document. Now, the question was very direct. It said in 1.2, what would you need from the seller, meaning Sweet Meat Pty Ltd, to show that Mr. Joe Soap had proper authority? Many people went and drafted a power of attorney and said that is the document you would need. And many even drafted mandates. There is no mandate or power of attorney if there isn't a resolution passed. So the document you needed to draft was the resolution in 1.3. Now, those who did draft the resolution, you could see it was some of them did prepare, some of them, were trying it, which is fine. But what we found in paper 3 is that small technicalities that would give you marks were basically, are things that candidates always slip up on, and that's actually free marks for you. For example, where the resolution was taken, in which place, on the date, those sort of things were omitted. Also, who was present and who signed the resolution. Then who can sign the agreement on behalf of the purchaser? Here, of course, we were testing on the terms of your matrimonial status if you are in and out of community of property. So you can see the mark allocation says 2 marks, and it specifically tells you explain your answer. Now you find many candidates just said Mrs. Khan can sign it alone or Mr. Khan can sign it as well, because they are married in community of property, or you say any other person can sign it, but you don't qualify it. So yes, somebody else can sign it if they were given authority to sign it. So the next question said draft a payment clause in the contract with specific reference of the purchaser's failure to secure the loan as per the above. Now, here it was, of course, your general clause in terms of your resolutive or suspensive condition. The question was quite broad in the sense that what we basically wanted was to be able to see that you are able to say that this is the amount that is secured. If you do not pay it, what will happen? Many students confused the resolutive and suspensive and actually tried to combine both in terms of this paragraph. So it was a drafting question. There were many ways in which you could have drafted it. Certain key factors, for example, where the loan is obtained from, within how many days, what is the amount, if you do not secure the loan, what are the consequences? That is what the answer basically entailed and what we were looking for. Question 1.6, under what circumstances would VAT be payable and by whom? Now, again, VAT could be, remember, the assessment is to see how do you advise your clients to the best of their interest, and at the same time, your ethical duty in terms of not prejudicing an unrepresented client. So when I talk about VAT and by whom it's payable, I need to give the different the instances in which VAT is payable. So I would refer to the zero rated VAT and how that is calculated, as well as if they not agreed to sell it as a going concern, then VAT would be payable by the purchaser. Now, you will find in this paper some of the answers you have to give may be warranted in your mind, maybe more than 2 marks. But you don't know in terms of marking what the examiner is going to do. Is it going to be half a mark for a fact, 1 mark? Remember, it's an overall assessment. There's guidelines in terms of what the answers must look like. So you cannot draft a power of attorney where it's supposed to be a resolution and expect any marks. So even if, for example, you had the date right or you had something right, the test is to see, do you understand the difference between a resolution and a power of attorney? And you find there is the problem of when you even have papers remarked. Sometimes your marks drop. Sometimes you think it's going to take you over the benchmark for not having to do an oral, but it's an assessment. So if you draft the wrong paper, the understanding is you don't understand a concept. It would work the same in paper 1. You cannot draft a special plea when you're supposed to do an exception. So in the same way, when you are drafting for paper 3, you cannot say, but I had the date right or the place right, but now I said power of attorney instead of resolution and you must get marks. In certain factors, like for example, the VAT in 1.6, there's 2 scenarios that they can be, but you need to give an explanation of it as well. Is VAT payable if the purchaser is not a VAT vendor and the seller is? Yes, it would be. To a certain extent, of course, the answer would overlap with your answer above. And on what day would stock be taken in by whom? Now, things of this nature, you need to sometimes put yourself in the practical situation and say, I'm selling a movable. When is stock going to be taken? How is it going to be taken? How would we do it? And it would usually be the day before handover. And of course, seller and purchaser or their representatives must be present. And then, of course, the purchasers indicated they are not interested in taking over the staff. This became a labor matter with specific reference to specific legislation. How would you go about in terms of fulfilling your obligations? This year was in terms of 197 of the Labor Relations Act. And what we were also looking for here is the fact that if you transfer the business and you don't take over the employees, what are their rights? And in the alternative, if you don't fulfill those rights, what are the consequences? If you look at 1.10, should they fail as per the above, what is the remedy of the staff? Of course, they would then go to the CCMA and report it in terms of unfair dismissal. We then look at your clause in terms of 1.11, which was your basic restraint of trade clause. And you were not penalized for the fact that you, to a certain extent, when you drafted the restraint of trade, your distance was unreasonable, time frames were unreasonable. You were not penalized for this. But as attorneys, we need to think about this practically. Can I impose a restraint of trade on someone who's just selling a restaurant in the food industry for a period of 10 years and within a distance of the whole of Gauteng, when this is their only kind of livelihood? It's debatable, but it's things you need to think about when you are drafting, which although you weren't penalized for, but there was a lot of that, and it's not a good oversight for attorneys to have. In terms of 1.12 draft, an indemnity clause to protect both as a result of the breach of an agreement. Many parties here went on to draft a breach clause, and it's the only part they drafted. So the question was actually twofold, because in the one sense we wanted the answer was looking for the breach, that you give a party a certain amount of days to remedy the breach, and if they don't, you can claim specific performance with or without claiming the damages. On the other hand, it also was referring to the indemnity in terms of your adverts that need to be placed in terms of Section 34 of the Insolvency Act, because you're selling a business as a going concern. Now, while insolvency might not have been something that was part of your syllabus, however, selling a business as a going concern means that you must advertise it. So even if you didn't know the section, there must be some repercussions with which come with not informing any of the creditors in terms of the business. When we look at 1.13, a dispute arises between the purchaser and seller during the negotiation or before signature. What is your duty towards an unrepresented purchaser? And in this case, a lot of people actually said that I will withdraw from the matter. It is not wrong to withdraw from the matter, but you've already drafted a contract. And I mean, there's potential for an attorney to have to be able to proceed with this matter. So that should not be your only answer. Many students wrote that as the only answer, that I would withdraw from the matter. And the fact that it is for 4 marks, you needed to explain that. So first you would have to address whether there is a conflict of interest, whether the reasons why you think there is a conflict of interest or there isn't. And of course, the fact that you can't represent both parties and there can be, he needs to seek independent legal advice. On 1.14, accept that the dispute has been resolved and that the parties have signed the agreement. Explain the exceptions when agreement may not be signed electronically. And of course, those come from the theory list, which I am not going to repeat here. But even if you didn't know the answer to 1.13, in the sense that you said, I want to withdraw as the attorney, 1.14 automatically led you to believe that you continued with your mandate. So your answer should have been along those lines. So it's important for candidates to look at the next question and then go back. So study a question as a whole, then try to answer them. So it kind of like guides you where you are falling short. In 1.15, it was about FICA, which was also covered in your syllabus, and it says that you see that there was a deposit made in cash. Here we wanted basically your compliance issues in terms of being an accountable institution. What do you need to do? Many people didn't know what the threshold was, so they referred to the wrong amount. And of course, the fact that how long you have within which to report it, as well as the fact that you have an obligation to report it. So what are the consequences if you fail to do so? It was that you could be held criminally liable and you could pay a fine. Many people went and said you'd be struck off the roll and you'd be suspended from practicing law. But those are consequences that would emanate later because you didn't comply. The question here was completely related to FICA, and again, 1.15 would have led you in terms of 1.16. In question 2, it was basically your cost orders in terms of what the court would grant. It was very interesting to see that in terms of 2.1, where defendant acted fraudulently and the attorney misled the court, people couldn't tell the difference in what sort of cost order there would be. So that was a pure theoretical question in terms of question 2. In terms of question 3, it was about the recognition in terms of your customary marriage and the consequences of such. Many people confused the two answers in terms of what it should be after the recognition of the Customary Marriages Act as opposed to before. Remember, before the wife would be treated as a minor and she had no legal standing. She could not do anything without the consent of her husband. Whereas after imposition of the act, the wife can now conclude contracts on her own. In terms of question 4, risks that are related to law firms, the risks that they face, I must tell you about a good amount of papers actually had a risk that was noted as candidates, which said that their lack of clients. That might be a downside to the business, but in terms of risk and in terms of what a business is concerned, those are things a party would consider in terms of your location and where your offices need to be. But the risk here, in terms of what was associated here, was more along the lines of cyber-related risk, labor, professional negligence, property risk, that sort of risk. When it came to certifying and commissioning a document, there were many who basically thought of certifying and commissioning as the same, which wasn't the same. You can see it's only for 4 marks, but again, you don't know whether it was half a mark per fact, 1 mark per fact. Basically, certifying is basically confirming that something is a true copy of an original, whereas commissioning means that you need to um, confirm the person in front of you is who they say they are, and that they are the deponent in terms of who has signed a specific document which they understand to be binding on their conscience. It was along those lines. Question 6, when it came to the justiciability of a court matter, this actually came from understanding the constitutional law. It comes from there. It's, however, applicable even in high court matters because constitutional matters can be in high court. This was simple in terms of whether matter was moot, whether it was ripe, whether there was a real or an actual dispute, and of course, do the parties have locus standi. When it came to question 7, it was more along the lines about the code of conduct, which was specifically mentioned in the syllabus, as well as certain sections in terms of the code of conduct, which you should have read. Many people, when they asked, what do you need when you start practicing, people went to say you need an LLB degree. And they said you need to pass your law exam, which actually isn't, I mean, the question is saying that you are an admitted attorney. So again, some people never read the questions when they answered that way. You needed a Fidelity Fund certificate. And of course, when may a legal practitioner terminate a client's mandate? This was about when can the legal practitioner terminate the mandate and not when the client terminates the mandate. Again, many didn't read the question carefully. And may his wife, an insurance broker with whom he wishes to share offices, may he do so. Provide a reason for your answer. Of course, anything that you want to do out of the normal, even if you didn't know the answer, is always that I need to get written consent. I need to approach the council because that is my body of rules, and I basically need to ask them. So it was not difficult in terms of that. Again, here the answer could have been twofold. It could have been yes and it could have been no. Yes, provided I get consent. No, unless I do get consent. So you were not penalized for that, provided you had a reason that qualified it. So you receive an offer from a corporate entity to join as a legal advisor. What steps would you require to close your practice? This here, of course, is the normal steps that you would require. It is in your code of conduct, which you can look at, and you can see the procedure in terms of what you need to do. Of course, you must submit your closing audit. Your subscription fees must be paid up to date. Files must be handed over. So the obligation that you have in terms of that I have people's files and people's information with me, how do I pass that over without prejudicing anyone? That's the main emphasis in terms of what was being tested here. When we go to question 8, the role of a mediator in mediation proceedings, here there was a lot of repetition. So in the one hand, you said a mediator must resolve matters and they do not make decisions, and they must be they must not be biased, they are impartial. But then there was also instances where the same facts were repeated, but you said it in different words. So it was just to list 5 facts and different ones insofar as that is concerned. So some people said that the mediator drafts the settlement agreement. How do you draft a settlement agreement if you have not reached a settlement as such? When you do the paper, and like I've said before, you need to evaluate it on the basis, or you need to answer the paper on the basis that the work is covered in the syllabus. But as you can see, it was practical based. If you look at question 1, it was about a restaurant. If you look at the other question, it was about these questions were more practical. There was a good amount of theory for you as well, where it was easy to score some marks. But even in the practical, all you had to do was apply the knowledge so that you could understand it and so that you could apply it in a given set of facts. So drafting a restraint of trade doesn't change. Drafting the payment clause doesn't change. However, you need to align it to the facts. One other mistake that was very common was the fact that students changed facts. Because they paraphrased and studied paragraphs that way, they changed facts and they aligned their answers according to that, which obviously threw them off the bus. When it comes to orals and it comes to paper 3, you must understand that your oral is de novo, and as my colleagues have pointed out, it doesn't mean if you have 49, you are going to be tested only for 1%. You can go to an oral and still fail it on 49% if it is established you are not fit and proper to go into practice. Now, the fit and proper in terms of paper 3 is basically based on theory applied practically. Remember, it also covers ethics, what your duties are as an attorney, what is expected of you, what you need to do. Um, I've also heard candidates say that they basically message each other and they tell each other after their oral, if one is an oral 8 o'clock and one is one 10 o'clock, they say to the other, this is what the examiner asked me, so, prepare these questions. First of all, that questions your integrity in terms of fit and proper. It's not good to do that for exam purposes. And secondly, examiners ask questions based on how a candidate answers. So it goes with the flow. You might find when you are sitting there, you are not before one examiner. So an examiner might ask you a question and another one might ask you a follow-up that is created subsequent to the answer you've given or the set of facts that they have now generated. So no two questions that an examiner asks one candidate to the other might always be the same. So we should not bank on that. We should not prepare for the orals like that. You must go into the orals with a level-headed mind, listen to the questions carefully, and answer them as concisely as you can, but to the point. Remember, there's no mark allocation there, but it is practical orientated and it's also coupled with theory. But on the whole, it was a fair paper. It was a good paper. Like Melissa said, the responses were good, but candidates need to read the questions carefully. They need to write more legibly sometimes, and they also need to write more clearly. Sometimes when you write, you don't get to the point. You say too much of what is not necessary, and then you run out of time and you say less of what is necessary. However, I don't think there was a problem with time because it seems as if everybody did finish the paper on time. So for those of you who do have an oral, good luck and all the best. Thank you.
Thank you very much, Hajira. Thank you for taking the candidates through paper 3, which is the attorney's practice and legal ethics paper. I think you've covered everything there that candidates can see maybe where they might have gone wrong. And you've provided some very good tips for those who are.
Laptop
Sorry. Sorry about that. So now I was just saying, Hajira, thank you very much. You've given the candidates some good tips for the orals, as well as for those who might be preparing for the exams next year. But overall, we were very happy with what we saw and the great improvements in these papers, and we hope to see that going forward as well. I know we're going a bit late, but I'm going to hand over now to Mr. Trichamji. I'm sorry, but it's been a very good session so far. Mr. Trichamji, without any further delay, please let me hand it over to you. Thank you, sir.
Thank you, Melissa. Thank you very much. I'm going to now deal with what I consider to be the easiest of your 4 papers, and that's the bookkeeping or accounting paper. I just want to repeat what has already been conveyed to you by my colleagues, that you must read the questions carefully. You're given 15 minutes to read the question and make maximum use of the time to understand what is required of you when you're answering the question paper. And I refer specifically to question 1. Now, if you take question 1, it's a normal, what we call a bank recon question, but we just changed it a little bit by asking you even a more practical approach to it. And the question clearly stated, it says, enter the transaction in the business cash book, balance the business cash book, compare the cash book entries with the bank statement, and then prepare a supplementary cash book and a recon statement. So many of you somehow or the other missed that. And when you were asked to enter the transaction in the cash book, like you take the ones that were given to you, and I refer specifically to June 10th, you receive by EFT an amount of 11,500 for a bail application on behalf of your client, Mr. Kaba. Many of you chose despite the fact that you were asked to write and make these entries in the business cash book, you chose to make this entry in the trust cash book. And we, as examiners, gave you the benefit of the doubt by not marking you down or giving you 0 marks for that. The same for the next one. You receive an EFT in an amount of 23,000 from client XYZ Pty Limited, being the agreed fees for an agreement that you prepared. Even that, many of you decided to open a trust cash book and make that entry. Other than that, that first question on the reconciliation statement, well, first of all, writing up the cash book and then preparing a supplementary cash book and the reconciliation statement was very well answered. I think the majority of you seem to have got it right. And those that got it wrong made the what I would call negligent mistakes because you either rush through your paper or otherwise, like I just said just now, and what has been done, I'm repeating what all my colleagues have said, you don't read the questions properly. You've got plenty of time. This was a 2-hour paper. Is now the time has been extended 2 hours and 30 minutes and another 15 minutes for reading. So you should have absolutely no reason to believe that you won't finish the paper. So read the questions properly. And I'm sure that those of you who know what bookkeeping is about would have got this right. Many of you got full marks, 20 out of 20 for this question, which indicates that you knew exactly what the question was all about and what was required of you. So from that point of view, question 1 was, in my view, well answered. Like I said, it was slightly different from your normal recon statement where we give you the differences that exist between the entries in the cash book and the entries in the bank recon statement. And of course, in this method here, you are doing you are carrying out the practical approach. What happens on daily life? You compare the bank statement and entries, and you compare the cash book entries. You tick off those entries that are common, and then you are left with entries that appear in the cash book that don't appear in the bank statement, and vice versa, where entries appear in the bank statement that don't appear in the cash book. And those entries, of course, find their way into the supplementary cash book, and the others form part of the actual bank reconciliation statement. Then the theory question, what books of account will you require? Most of you, what you call, answered that comfortably. And then how many bank accounts will you open and what specific instruction will you give with regard to bank charges? Many of you didn't quite answer that correctly. Uh, the rule regarding bank charges is very, very clear. The first one is all bank charges must not be debited to the trust banking account, must be debited. The trust bank charges must be debited to your business banking account. And alternatively, if you give the bank instructions, the bank opens what we call a specific trust bank charges account, where the bank charges are recorded as well as the interest that is earned on the trust bank balances. So that was the answer. Well, other than that, question 1 was fine. Question 2 was what we call a correspondent. I think all of you know that. We call it agent's account. There was nothing here that was different. It was straightforward. How do you go about making entries? Because now, normally you would instruct an attorney in another jurisdiction where you would expect the attorney to carry out your instructions and account to you. In this case, you receive the instructions from your correspondent attorney. You did the work and you recorded the entries as you would in your books of account, and then you accounted to the correspondent. Here again, we found no serious problems. I think majority of you knew what you were doing, except that some of you still make careless errors. Sometimes when one is marking a paper, you can actually feel as you are going through the paper that the candidate's paper that you are marking knows what he's accounting all about. But then suddenly, out of the blue, you get a totally reckless answer, which means that the candidate didn't think before recording that entry. So that is the only observation I can make insofar as question 2 is concerned. that you have to be like, you got so much of time. Take your time, read the question, read what is required of you, and then consider it, and then apply your mind, and then put pen to paper. You can't go wrong then. Here again, there were many candidates who actually got full marks in this question as well. Then question 3, again, second question was the agent's account. Question 3 was a property transaction, or what is commonly known as a conveyancing transaction. But more importantly, what was asked of you here was your ability to recognize the difference between the trust accounts that you can open, and with specific references to investment, the Section 86.3 and the Section 86.4. How you distinguish between those two, how you deal with the interest where there's a Section 86.3 investment, and how you dealt with the interest when you have a Section 86.4 investment. Here again, I must concede that the majority of candidates got that 100% correctly. It seems like you knew exactly how to deal with the interest. You correctly recorded the interest paid that is payable to the Fidelity Fund, the 5% that is normally paid to the Fidelity Fund when you get a Section 86.4 investment, which is an instruction from your client to invest on behalf of your client for your client's benefit. So other than that, the question was extremely well answered. There was just some of you were somewhat, I wouldn't say put off, but you didn't quite follow what is meant by an estate agent's commission. And the word agent seems to have been the red herring for me. Some of you thought that agent means the agent who is instructing you, which has nothing to do with that. An estate agent's commission is nothing more than a simple disbursement payable by the seller from the proceeds of the purchase price. That's all. So other than that, that question was, in my view, extremely well answered as well. And then the last question, with regard to the theory. Now, one gets tired, and I am privileged to be able to lecture to many candidates at the practical legal training school. And I repeatedly plead with the candidates and say, please, the difference between input and output VAT is so easy. Don't confuse the two. And, and despite that, we still found not a few, many candidates who got the definition of input VAT and output VAT the other way around. Now, there is no excuse for that. There is absolutely no excuse for that. It's not a question that is impossible to answer. It is not a question where you even need to think. You should know what input VAT is, and you should know what output VAT is. Output VAT is the VAT that you charge, and input VAT is the VAT that you pay. It's as simple as that. But other than that, the other questions there that were asked, the limit, when do you have to register for VAT? Again, many of you got that right. The one question that seemed to have, I wouldn't say trouble, but many of you didn't even answer that question. What is the difference between a legal practitioner practicing with a Fidelity Fund certificate and a referral practitioner? And many of you either didn't answer that, or you simply just got it wrong. You didn't know exactly what it means. And here again, one practicing with a Fidelity Fund certificate must open a trust account, right? I think that's the requirement. If you want to practice as with a fund certificate, then you can deal with trust money. You have to open a trust account and make special arrangements with the bank. And of course, most importantly, how the money is deposited in your trust account and how you account for it, right? And of course, the referral legal practitioner is one, they can't receive any trust money. They can't take money from client in advance as cover for fees. They just have to wait until they complete the mandate and then get paid thereafter. Other than that, I'm very pleased to say that I thought it was a pleasure marking the scripts this time. The majority of you passed. Melissa, I didn't ask you how many percent passed the written paper, but I'm sure that there is substantially more than 45%, if I'm or 40%. And those of you who get to the oral, please. I just want to repeat what Ms. Kara has just indicated to you. Do not prepare yourself for questions in advance from what you hear from other candidates who have already gone for an oral examination. Each candidate is asked questions depending on the examiners on how they ask you the questions. They're not necessarily going to ask you questions from the paper. They may ask you questions in those areas. They don't have the paper in front of them, but they have your marks. And if they find that for instance, to use the example, you had not answered your questions well, or you didn't do well in answering the question on the conveyancing section, the property section, then they might ask you questions on that section just to test your knowledge. But other than that, accounting, there are no tricks involved. There are no shock questions. There are no questions that have never been asked before because accounting is accounting. There's one rule that governs accounting, and of course, the rest is all, like I always say when I lecture, it's all arithmetic. So, those of you who are attending the oral examinations, I wish you all the very best for the oral examinations. Good luck. And Melissa, thank you very much.
Thank you very much, Mr. Trekhamji, and thank you for going through the paper. I know it's very straightforward what's expected of candidates. So please go, candidates, please go and practice as much as you can so that you'll be prepared for the next exam for those of you who maybe didn't make it yet. I just want to take this opportunity now. I know we're a little bit over time, but I want to thank our 4 presenters that we had today who've taken you through papers 1, 2, 3, and 4 that were written in August 2024. I hope that going through this webinar and sharing this information with you has really helped those candidates who might be preparing for the oral exams, or for those of you who haven't made it yet, we hope that it assists you in your preparation for next year. Before the next exams in March 2025, we will have preparation workshops. So you will be invited to join us then for any of you who might be writing exams in 2025. We have run out of time for questions and answers. So please, if you do have specific questions, please email me. You can send the email through to info@lpc.org.za for my attention. That's attention Melissa. So again, I'll repeat, it's info@lpc.org.za. Please send your questions through and we'll get to you as soon as we can. Again, thank you to the presenters who were with us today for your expertise and your experience and for sharing some tips with the candidates as well. I really trust that the session has been beneficial to candidates, and the session is now adjourned. Thank you very much, everyone, and we'll see you in our next workshop. Thank you,
Melissa.
Thank you very much. Thank you, everyone.
Thanks,
Okay.
Melissa, and to my colleagues, thank you.
Thank you very
Thank
much.
you.
Thank you.
Thanks.
Thank you.
Thank you, everyone.
Bye.
Thank you.
Bye.